everybody. Today, obviously, if you're watching this, I am not here. Um, but, actually, let me see if I'm even recording this. Am I recording? Yes, I am. Oh, there we go. All right. Now, what's going on here? Hold on, guys. I'm sorry. All right, there we go. All right, now we're good. All right, so today I'm not here. So we'll be talking about defenses today. On Wednesday, I should have given you guys some of the notes to go along with this. So hopefully you're watching this and you're filling this in. By the way, your test is going to be next week. I'm shooting for next Wednesday for this unit. So you're going to be using the notes packet that I gave you guys from a little while ago, about a month ago, and you're going to use this one as well. That will be included on Monday. We will review for the test. All right, so today we're talking about defenses. So if you're accused of a crime and you believe that no crime has been committed, you and your defense lawyer would say that simply your defense would be no crime was committed, there was a mistake. So an example of that would be carrying a gun, but you had a valid license. So if you can show proof that you had a valid license, well then at that point, that would help evidence for you that no crime was committed. Rape versus consensual sex, that if you were accused in a rape case and you in your defense is that it was consensual, that would be, in your view, no crime was committed. Also, criminal intent. No crime has been committed, but so you had no criminal intent. So maybe it's, again, unintentional, it was an honest mistake, or it was a reasonable mistake. So again, those would be your defense choices in cases like that if you were pleading that no crime has been committed. Now, you say the defendant did not commit the crime. I didn't do it. There was no doubt a crime was committed, but I did not commit that crime. Maybe you were accused of robbery. You're accused of murder, whatever the case might be. Obviously, the murder happened. The robbery happened. Obviously, things were stolen. But your claim is that you did not do it. Now, something that would be needed would probably be some things that would help your case would be an alibi. An alibi is like a statement of kind of where you were at the time that the murder, robbery, whatever occurred. So if you have witnesses that can pinpoint you to that location at that time, that will definitely help you out. DNA evidence. If there's no DNA evidence at that location, that will definitely prove your alibi. Do you have any records to prove that? So, like for instance, if you were using the turnpike, a time card at work, phone calls that can pinpoint kind of where you were located at. And those are all things that can help support your alibi. Now, if you're somebody who doesn't have any of those things, and it's your word versus their word, then you're kind of rolling the dice a little bit. So that's why alibi is very important to prove that you did not commit the crime. All right, another thing, the defendant committed the act, but so now you have a couple things here that you can kind of talk about here in terms of defense. One could be self-defense. I committed the crime, but it was out of self-defense. I was defending myself. I felt threatened. Another thing could say, well, I was defending my property. Or you could say I was defending others. So with that being said, kind of opening it up to a couple examples here. Self-defense example. Now, again, I committed the act, but I did it out of self-defense. So you have to prove that reasonable force was justified in that particular case. You have to feel like there was an imminent threat of violence. You felt like your life was on the line. You had no chance to retreat, whatever the case might be, that you acted out of self-defense. Again, there must be imminent danger of bodily harm. You cannot use more force than appears that is necessary. So, like for instance, if you are defending yourself and you have somebody on the ground like knocked out cold, you punch them, they're knocked out, and you're on top of them, you keep swinging, you keep swinging, you keep swinging, you keep swinging until the person's basically dead. And it shows that you hit the guy over 100 times or 50 times while they're on the ground, whatever, and they were no threat to you anymore. That would obviously be more force than what you needed. If after stopping the attacker, the person continues to use force, then the roles reverse. Now you become the attacker. Now, something that has been kind of in the news as of late was something called the Stand Your Ground Bill. And actually, this was just passed, or I shouldn't say passed, but it was just expanded this past January. So Stand Your Ground means that deadly force could be used when imminent danger or of death or serious bodily harm is believed to be in danger of yourself. So at one point that only applied to your home and to your vehicle. So for instance, you didn't need to retreat, hence you could stand your ground. You don't need to retreat, you don't need to run. If you can, you have the right to stand your ground, and if you feel like your life is in danger or you're feeling threatened, you could stand your ground and use deadly harm. Now, as of January, Governor DeWine expanded that to any legal place that you have the right to be. So out in public, if you're at a stadium, you buy a ticket, you have the right to be there. So now that's expanded to all parts of society now. You could stand your ground, you could use deadly force. Now part of this too, of why this bill is controversial, because now the prosecution, when they're prosecuting you, so before stand your ground, when this didn't exist, you as the defendant, if you were suspected of murder and you were saying I was using self-defense, you had to prove that your life was in harm. Well, now with this new law, now the prosecution has to prove their case. So it puts more power into us as individuals, as citizens, dealing with a case where our life is feeling threatened, and as long as gun owners too, gets more power into their hands too, that to use their weapon if their life is feeling threatened. So kind of interesting little law that was just passed that kind of has critics on both sides, support and critics on both sides. Now, also the defense of others could also be a reason. So if a third party can claim self-defense, a person can use deadly or non-deadly force to defend them. So again, if you're out in public and you see a third part, if you feel like somebody else is being threatened, you're used to protect somebody. Again, same thing for that. Defense of property. Reasonable non-deadly force may be used to protect property. So some states, again, the Castle Doctrine. I just talked about this. Castle Doctrine or stand your ground. This applies to your home. You don't need to flee. You don't need to leave or escape. You have the right to stand your ground and use deadly force if needed, if there's an intruder. So I have to add Ohio to this list, by the way, because Ohio just passed it just recently. All right, so that's a defense you could use there. Now you have the defendant is not criminally responsible, and that's a defense. Now there's different types under this category now. So we'll talk more about these individually: infancy, intoxication, insanity, entrapment, duress, and necessity. All right, so infancy. Usually children under the age of 7 are incapable of committing a crime. So infancy would be a 7 to 14-year-old, generally presumed incapable of committing a crime. But in some states, it is up to the prosecution to decide on it. So a juvenile case or an adult case. So again, most times, if you're 7 to 14, you're going to go the juvenile route. But if you get closer to 17, especially kind of high case, like a murder case, the prosecutor could decide to choose adult. But again, most time it's considered would be an infancy case, a juvenile case, 7 to 14. You can also claim intoxication. At the time of the crime, a person was so drunk or high they did not know what they were doing. So only if the intent is required for this crime. So intoxication is a defense case. So again, it doesn't mean that you're going to be let off. It just means that it holds you less responsible if you're under the influence. So it's intoxication defense. Insanity. In some states, to claim insanity, you must have a mental disease or disorder, and you do not know right from wrong. In some states, if you do not have substantial capacity to confirm your conduct to the requirements of the law, you'll be acquitted. So there's certain things for that we'll talk about here in a sec that will kind of help prove insanity. But again, it's something that's important that it needs to be diagnosed. If this were to be a defense, the person would be evaluated for this. So here's some questions to kind of go over. The defendant is competent to stand trial. So somebody would evaluate you and would determine, that are you competent? If not, mental treatment until they are competent would be needed. 2, defendant was insane at the time of the crime. So these are in outcomes. Outcomes could be not guilty due to a mental defect. Guilty could happen if the jury doesn't believe the person was insane, or guilty can happen if you were guilty but you're mentally ill. So there is some differences in terms of sentencing for that. The defendant is insane after the trial, treatment until sane, and can go back to prison. So examples of this. So again, defense needs proof of mental disease or defect by psychiatrist. They need to diagnose that. So there's three types. There's temporary insanity, insane only at the time of the criminal act. There's diminished capacity, which you're not insane, but was not capable of comprehending nature of the act at the time due to emotional distress and mental incompetence. You're incapable of understanding the charges against them, and so the attorneys will consult. So examples of this too, insanity, especially like, at the time. If I walk into my wife, she's having an affair, and I see it, I might lose my mind. I might not be thinking clearly. Now, I might be a teacher, I might be a complete sane person, but I may have temporarily lost insanity. That could be something that could be possibly proven, or at least understood in the court of law in terms of something traumatic happens in your life that you temporarily lose your rational thought. So that'd be an example of that. Entrapment. The defendant admits to a crime but claims that he or she was induced or persuaded by law enforcement. So they believe law enforcement, urged you, persuaded you, pushed you to commit a crime. That would be entrapment. There is no entrapment if a police officer merely provides a person with opportunity. So they go undercover, they buy drugs from you. That's not entrapment. They're trying to purchase drugs from you. Cannot be claimed as a defense for serious physical injuries like rape and murder. So again, entrapment, if a police officer kind of goes above and they're really trying to persuade you, really pushing you or threatening you to do something, to commit crime, that would be entrapment. Duress. A person acts under duress when they do something as a result of coercion, twisting your arm, or threat of immediate danger. So like, for instance, if you're in a car and somebody hops in your car and holds you at gunpoint, and they're telling you to go 100 miles an hour to rob a bank. Okay, well, you were under duress. You were in immediate danger of your personal safety. Was on the line there. And then necessity. A person compelled to react to a situation that is unavoidable in order to protect their life. So lifeboat, set adrift, throw over belongings to make room for more people. This is not a defense to murder. You cannot throw over people to make room for other people. So you have to commit something. You have to break a law because it's a way to react to something. All right. So this is what you need to do. You're going to have these things down. Hopefully these are all in your notes. And what you're going to do is you're going to go in Google Classroom and you're going to fill out this criminal defenses sheet. You're going to go through the different scenarios here, and you're going to fill this out, deciding which one, and explain your answer. Don't just put entrapment. If you think this is entrapment, explain why you believe that. What facts from the case make you believe that? So that's really all that you need to do today. There will be a Quizlet for you guys as well to help study for the test next week. So if you do finish early, which many of you guys probably will, go through and finish your study guide or look through Quizlet. That will help you with the test. All right, adios. Have a good one, and I'll see you guys later.